Hello, dear readers. Welcome back to the podcast. Welcome back to the podcast, Legal Conversations, episode 8. In the last episode, we discussed episode 50 and 51, where we spoke about the procedure before the arrest, and the general conduct of search. Action before a search, procedure before a search takes place, I beg your pardon. Section 50 and general conduct of a search. Now we're going to be discussing the search of an arrested suspect, section 52, and then examination of arrested suspect. How is an arrested suspect searched? And section 52, section 53, and then we'll see if we can do more. Section 52, subsection 1. Now, where a suspect is arrested by a police officer or a private person, remember we said a private person can effect an arrest. Where a private person effects an arrest, you should immediately hand over the person to a police officer or take the person to a police station. And the officer, where he takes the person to a police station, the officer should immediately rearrest the person, right? I think we already discussed that. Now, where a suspect is arrested by a police officer or a private person, I'm reading section 52, subsection 1 now of the Police Act 2020. Where a suspect is arrested by a police officer or a private person, the police officer making the arrest or to whom the private person hands over the suspect may search the suspect if the police officer has reasonable grounds for believing that the arrested person may present a danger to himself or others. So where the police officer believes that the arrested person may pose or present danger to himself or to others, he has reasonable ground to believe that such a person may be endangering himself or others, he may search the person. Now, 52 subsection 2. A police officer shall also have the power in any such case to search the arrested person for anything A, which he might use to assist him to escape from lawful custody, or which might be evidence relating to offense. So, a police officer can also search, apart from the fact that he has reasonable ground to believe that he might be carrying an object, or he may be presenting or endangering himself or others, where a police officer may conduct a search of an arrested person for anything that might have been used to commit an offense, or for anything he may use to escape from lawful custody. That's what section 52 subsection 2 talks about. Section 52.3. Now, where an arrested suspect is admitted to bail and bail is furnished, he shall not be searched unless there is a reasonable ground for belief that he has on him A stolen article, B an instrument of violence or poisonous substance, C tools connected with the kind of offense which he is alleged to have committed, and D other articles which may furnish evidence against him in regard of the offense which he is alleged to have committed. So, where a suspect has been admitted to bail and is furnished, and he shall not be searched. That's the general rule. However, where there is reasonable ground that he has on him a stolen article, an article that is stolen, an instrument of violence or poisonous substance, tools connected with the offense, with the kind of offense which is alleged to have committed, and other articles which may furnish evidence against him in regard of the offense, he may be searched. He may be searched. Now, 52.4. Now, the power to search conferred is only a power to search to the extent that is reasonably required for the purpose of discovering anything or evidence. So the power to search under this section, the power of the police to search under this section should be moderately utilized. This is what section 52.4 is talking about. Section 52.5. The powers conferred under this section to search a person are not to be construed as authorizing a police officer to require a person to remove any of his clothing in public. Take note. Remember that in episode 7, the last episode where we discussed 50 and 51, we said the police shall minimize, I think it was 51. We first read section 51 and then we went back to section 50. We said a police officer should minimize the amount of embarrassment which a suspect might face during search. Remember, and we said he shall not search anybody where he feels like he shall only search the outer clothing, and when he feels like searching the inner clothing, it shall be done in private by the officer of the same sex, blah 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 blah. Listen to episode 7 again, please. Now section 52 subsection 5 is now saying that the powers conferred on this section to search a person are not construed as authorizing a police officer to require a person to remove any of his clothing in public. Okay, so even though you may want to search, you must not ask the police officer cannot ask a suspect to remove any of his clothes in public. Okay, now 52.6. Now, a police officer may not search premises in the exercise of the power conferred on him under section 2B, unless he has reasonable ground for believing that there is evidence for which a search is permitted under the paragraph on the premises. Okay, now 52.7. A police officer shall place in safe custody all articles other than necessary wearing apparatus found in the suspect. Of course, everything obtained from the suspect, everything collected from the suspect, every article recovered from the suspect has to be properly kept. Okay, now examination of arrested suspect. Section 53, subsection 1. Examination of arrested suspect. Section 53. Examination of arrested suspect. Now 53, subsection 1. So, subject to the provisions of this section, an intimate search of a suspect may be carried out if a police officer of at least the rank of Assistant Superintendent of Police has reasonable ground to believe that the suspect is in lawful custody. A. May have concealed on him anything which could be used to cause physical injury to himself or others, might so use while he is in police detention or in custody of a court. B. That evidence of the offense alleged to have been committed can only be gotten from examination of the suspect. So, a police officer of not less than the rank of ASP, Assistant Superintendent of Police, may search an arrested suspect where it is believed that the person might have concealed on himself anything that could cause physical injury to himself or others. For instance, a knife, a dagger, or any of those things. B. Anything he might use while he's in police custody on detention of a court. Okay, and then anything that may constitute evidence of the offense which he has committed. Now 53, subsection 2. An authorization under subsection 1 may be given orally or in writing, and where an oral authorization has been given, it shall be confirmed in writing as soon as practicable, specifying the grounds for the intimate search. Okay, so an authorization may be given by a superior officer to the ASP. Remember, we said it must not be lower than the rank of the ASP, Assistant Superintendent of Police. And the authorization may be given either orally or in writing. Now, where it is given orally, it shall be confirmed in writing as soon as practicable. Okay, now a police officer, 52.3 now. A police officer carrying out the intimate search shall inform the person who is to be searched of the following. 1. The purpose of the search and the authorization and grounds for the search. Take note. The purpose of the search and the authorization and grounds of the search. So you don't just search arbitrarily. You want to search a suspect, you will tell the suspect, you shall inform the person who is to be searched, okay, the purpose of the search and the authorization and grounds for the search. 53.4. An intimate search shall be by way of examination by a suitably qualified person. Okay, suitably qualified person. We don't know what that means, but we believe that a woman is only to be searched by a woman, and a man is only to be searched by a man. I think we mentioned this in in episode 7, section 50 and 51. Okay, so an intimate search shall be by way of examination by a suitably qualified person. Okay, so I want to believe that's what it means. A man shall be searched by a man, intimate search. A woman shall be searched by a woman. Okay, now 53, subsection 5. Where an officer of the rank of at least Assistant Superintendent of Police consider it impracticable for an intimate search to be by way of examination by a suitably qualified person, the intimate search may be carried out by a police officer at the rank of sergeant. Okay, take note. Where an officer of the rank, I don't know the ranking of the police force. I don't know whether a sergeant is higher than ASP or a ASP is higher than sergeant, but I think ASP is higher than a sergeant. I'm not sure. Okay, all right. So where an officer of the rank of at least ASP, Assistant Superintendent of Police Officer, I'm reading from section 53, subsection 5 of the Police Act now. Where an officer of the rank of at least Assistant Superintendent of Police considered it impracticable for an intimate search to be by way of examination by a suitable qualified person, the intimate search may be carried out by a police officer at the rank of sergeant. Now, subsection 6. An intimate search shall be carried out by a suitably qualified person or sergeant of the same sex as the suspect. You see that? It's a necessary precaution so that they won't say the man is searching the woman, is caressing the woman, and is groping the woman or whatsoever. So I believe it's a precautionary measure. Now, 53.7 now. No intimate search may be carried out except at the police station, at the hospital, or at some other place used for medical purposes. Take note, no intimate search. No intimate search may be carried out 7 at the police station, at the hospital, or at some other places used for medical purposes. Now, 53 subsection 8. If an intimate search of a person is carried out, if an intimate search of a person is carried out, the custody record relating to him shall state 1. The authorization by virtue of which the search was carried out, who authorized the search, the ground for giving the authorization, on what ground was the authorization given, the fact that the appropriate consent was given, which parts of the body were searched, and why were they searched. Okay, take note. If an intimate search of a person is carried out, the custody record relating to him shall state the authorization by virtue of which the search was conducted, the grounds for giving the authorization, the fact that the appropriate consent was given, which part of the body was searched, and why they were searched. Now, section 53, subsection 9 now. The information required to be recorded by subsection 8 shall be recorded as soon as practicable after the completion of the search. So, subsection 8 is simply that where a person is searched, the custody record shall show the authorization, who gave the authorization, on what ground, the facts, the part of the body that was searched, and why they were searched. So 9 is saying now that the information required to be recorded shall be recorded as soon as practicable immediately after the completion of the search. Now, subsection 10. The custody officer of a police station may seize and retain anything which is found on an intimate person that has been searched, or cause any such thing to be seized and retained if he, 1, believes that the person from whom it is seized may use it to cause physical injury to himself or others. Okay, he may use it to damage property, he may use it to interfere with evidence or assist him to escape. And if he has reasonable ground to believe that it may be evidence relating to an offense. So anything that was recovered from an intimate search conducted on a person, maybe a suspect, okay, may be seized and detained if the officer conducting the search have reasons to believe that such thing may be used to cause physical injury to himself or others, that is, to the person searched or other people. It may be used to damage property. It may be used to interfere with evidence. It may be used to assist him to escape, or he has reasonable ground that it may constitute evidence against him relating to the offense. That's what subsection 10 is all about. Now, we are still on section 53, subsection 11 now. Where anything is seized under this section, the suspect from whom it is seized shall be told the reason for the seizure unless he is violent or likely to become violent or incapable of understanding what is said to him. Okay, so where any article is recovered from the suspect and is seized, the suspect from which it is seized shall be informed, okay, of the reason for the seizure, okay, unless where the suspect is violent or likely to become violent, incapable of understanding what is said to him. Subsection 12, section 50. We are still reading section 53. It's a long section. Okay, now, subsection 12. Where the appropriate consent for an intimate search of a suspect was refused without good cause. Where the appropriate consent for the intimate search of any suspect was refused without good cause. In any proceeding against the suspect for the offense for which the search was required, the court, judge, magistrate, or presiding judicial officer may draw such inference from the refusal as it is considered proper. Okay, so where the consent for an intimate search was refused, okay, the judge or the judicial officer or the magistrate may draw such inference that is, considered necessary so as to deliver a judgment. Maybe the suspect is hiding something, so the judge may construe that to mean whatever she construes it to mean. Okay, and that will guide her in delivering the judgment. Okay, so let's go to subsection 13, section 53, subsection 13. Every quarterly report submitted to the Attorney General pursuant to section 47 of this act shall contain information about searches under this section which have been carried out during the period to which it relates, blah blah blah. Subsection 14. The report on the searches referred to in subsection 13 shall include the total number of searches conducted, that is, every quarterly report that is submitted, Now, the report will include the total number of searches conducted, the number of searches conducted by way of examination by a suitably qualified person, the number of searches not conducted by a suitably qualified person but conducted in the presence of such a person, and the result of the searches carried out. Then subsection 15. In this section, suitably qualified person means a registered medical practitioner or nurse. Take note. So, suitable qualified person that we mentioned in subsection, is it 6 or 7? Thereabout. Simply means a medical practitioner or a nurse. Okay? The medical practitioner or a nurse. Thank you very much. In the next, this is episode 8. In episode 9, we'll continue on where reasonable suspicion never exists. Okay? Thank you very much for joining the podcast. See you in the next episode.